Well, a very good evening. This is a very special edition you're watching with me, Geeta Mohan. 6 lakh crore is the amount of black money that many estimate remains illegally in foreign accounts. Despite UPA's promises of bringing back India's lost wealth, nothing happened in the previous government's 2 terms in office. Now we may perhaps know exactly why. Rahul Shivshankar, our editor-in-chief, joins us for details on this very big story.
Yes, today for the first time, Geeta, here on NewsX, we have been able to access the exclusive sightings from the former Solicitor General of India, Gopal Subramaniam's defense of the black money issue. Remember, the UPA government had challenged the Supreme Court on the issue of setting up the SIT. Now, for the first time, this has not appeared in print or TV media ever before, electronic media ever before. We are going to break down the 9 specific objections the UPA had to why the SIT should not be set up in the Supreme Court. Some people are saying that this was an attempt by the UPA at subterfuge, at stalling this particular SIT. This is, of course, a claim that has been made by the Bharatiya Janata Party repeatedly. Today, for the first time, we are putting that claim to test. And 9 bizarre on the face of it pretexts were extended as legal arguments by the UPA to suggest that there was no need to set up an SIT to probe the black money issue, to probe the black money holders, to probe the entire trail that extended into banks across Switzerland, Germany, and several other countries, including those in the Pacific Isles, which are known havens for black money holders. This is a definitive expose which goes into minute details of that defense. There are nine pretexts. 9 pretexts which sum this entire defense up. 9 pretexts which, if one breaks down, don't stand up to logical at any level scrutiny. And this is specifically what we're going to be looking at over the next 20 minutes or so. We're also going to be going across to our panel of experts, including the Congress spokesperson Jaiveer Shergill. We are going to be joined by Sunil Alag, industrialist from the Noida studio, Professor Madhav Nalapat, the editorial director of the Sunday Guardian, esteemed and noted jurist KTS Tulsi, an MP and a former Assistant Solicitor General of India. Also, Justice retired Santosh Hegde, former Justice of the Supreme Court of India. He's going to be with us from Bangalore. Let me, however, pull up each one of these graphics to get a sense of what really was the government's defense, the previous government, the UPA's defense. So we are pulling up our first graphic here, and you can see it on your screen. The first pretext is that there was no need to set up an SIT, said Mr. Gopal Subramaniam in court, because there was no request made by the petitioner seeking such an SIT or seeking disclosures in the black money story. So the contradiction here is, of course, that the Supreme Court and the High Courts have plenary powers to order an SIT. Many people said that this was a frivolous intervention on part of the UPA, a frivolous intervention on part of the Solicitor General. Now, this is, of course, a qualified argument. It will need to be examined. Let's go on to the second pretext. The second pretext that the UPA took was the SIT interferes with policy, impinges on doctrine of separation of powers. The contradiction here, as you can see on your screens, is that it's a delaying tactic. The SIT can't interfere in policy. It has a very, very brief and a very specific mandate. It can't cross those limits. It has no binding powers on the executive, etc. So that was also something that the Supreme Court shot down and did not. And a very specific mandate. It can't cross those limits. It has no binding powers on the executive, etc. So that was also something that the Supreme Court shot down and did not think stand it up to legal scrutiny. The third pretext, the SIT will cripple functioning of statutory bodies, and therefore there was no need to set up an SIT. The contradiction here is that it's a bizarre argument. The Supreme Court had slammed the UPA for a slow probe. So many people saw this as some sort of an tool or a ploy to delay, to drag out this entire case. The third big pretext was that the SIT jurisdiction was not the fourth. Now let's go across to the fourth one. The fourth big pretext is coming up on your screens. SIT jurisdiction is not defined, could shut down the government's machinery because of its scope. The contradiction is that there is no basis for such a claim. The UPA appeared to be hiding facts. This is a contradiction that people have extended, legal experts have extended once they went through this defense. The fifth pretext, the SIT would probe unverified inputs and therefore it would lead to exposés and obviously embarrassment for several others. The contradiction here is, and if you look at this on your screen, the SIT scope is well defined. Broad investigation preferred in such matters. Let's look at the sixth pretext, objection to inclusion of sensitive office of RNAW in the SIT. The government said there was no need to have an RNAW officer, a research and analysis wing officer in the SIT. They said that the inclusion of an RNAW officer could affect intelligence operations. The contradiction here, of course, is that the present SIT has an RNAW officer, other SITs have an RNAW officer, especially the ones that were set up to investigate the Gujarat 2002 riots. No one had a problem with that SIT, but this outgoing government did. The UPA had that problem. Let me also bring in Kartikeya Sharma at this point. We'll go through 7, 8 and 9 in just a few moments. Kartikeya, point by point, we are bringing out the pretext that the UPA used in court, pretext that it used in court to oppose the setting up of an SIT. If one was to analyze each one of these pretexts, many people say they don't stand up to legal scrutiny. We know, of course, that the NDA also dismissed them summarily and the Supreme Court dismissed them summarily. So why fundamentally were these pretexts relied upon? Was this an attempt at subterfuge? Was this really someone briefing the Solicitor General in a way that could have strung out the entire investigation, led to at some level or the other the stalling of the creation of an SIT so that this entire issue could fall into the morass of the legal system and be continually covered up? Is that the reason? Kartikeya.
Rahul, three things are very clear when we go through these papers. One, that the opinion of the Solicitor General in written to the courts was that it should not be formed because it does not come under the domains of the court. It comes under the domain of the Parliament. Now, the second thing which is clear is that not only in terms of SIT, but there are certain features of SIT which court was talking about was found to be highly objectionable. And third, this continued for 2.5 years. Till 2014, 20 days before Lok Sabha elections, the government had actually again approached the court for a revision. Now the issue here is that since there is a huge debate on black money and the intention of getting black money between NDA and UPA and Prime Minister again going for a black money issue in Man Ki Baat, which took place 48 hours back.
Yes.
One thing becomes very clear, that UPA in its tenure did not show the intention to form an SIT or a systematic body to retrieve the money or retrieve the accounts or retrieve the knowledge and information about it. This is a summary of the intention, Rahul. That's the key.
Well, that's interesting, because if that's the spin that is being put, it's a serious one, which is serious implications for the UPA. Let's go to pretext 7. In this pretext, Mr. Gopal Subramaniam argued, of course, he was arguing a brief that was given to him by the UPA government, certainly those that were formulating this higher up in government, the law minister, perhaps others, that the SIT scope is unbridled, he said, could even suggest institutional changes and violates constitutional law. This is what the UPA argued when it said, or at least tried to extend reasons why an SIT should not be constituted. The contradiction here is that SIT recommendations on institutional changes are not binding. So, under the aegis of the law, none of what it could suggest to make institutional changes are binding upon the executive. So they could happily have been ignored. This was overlooked. Pretext 8. Retired judges on panel to investigate black money would be contrary to the SIT probe, SIT scope really. The contradiction here is that It's a bizarre logic. It's a bizarre logic because this has happened in the past. Many SITs have been set up and they have been, in fact, run and headed by retired judges. So that's a contradiction in terms. It's a contradiction in precedence. Pretext 9. SIT with retired judges will be serious impediment in the conduct of fair trial in lower courts. The contradiction here is that UPA had overruled similar objections in ordering other SITs. So here is an example of the UPA government coming out with a particular position which itself had overruled in the past in the context of setting up of other SITs. Now, we have been speaking to individuals in the NDA, others who have assessed this, and many people say that perhaps the UPA was falling back on legalities in order to stretch out this particular probe. Is that really true? Let me bring in some of our panelists. Mr. KTS Tulsi first, before I bring in Jaiveer Shergill of the Congress. Mr. Tulsi, let's go through some of these pretexts one by one. I want to pull up those pretexts on our screen. Pretext 1. Let's bring out pretext 1 once again. No request for an SIT was made by the original plaintiff, said the UPA government when it argued its case against the setting up of an SIT in the Supreme Court. Sir, do you think this stands up to legal scrutiny, Mr. Tulsi, given the fact that the SCA and HCA have plenary powers to order SITs? Why do you think such a plea would have been taken,
yes,
Mr. Tulsi?
I do agree with you that this was a rather technical argument, but I do not agree that it was merely a pretext with regard to all the other arguments that were advanced by Mr. Gopal Subramaniam. Mr. Gopal Subramaniam's arguments were based on the fact that in 2003, the government had enacted Prevention of Money Laundering Act 2003, and under that law, Financial Intelligence Unit had already been set up, which was precisely for this purpose. The Enforcement Directorate had been empowered under Section 3
yes.
of the Prevention of Money Laundering Act to go after the proceeds of crime. So there are agencies which could do this far more efficiently and far more speedily. The obligations on banking were created under this law,
yes.
and the financial institutions were required to inform the government about all suspicious financial transactions across the board. Then security market under this law was asked to keep records and information, verify the identity and report
yes.
all. So therefore these were the measures which were taken by the government to go after the organized gangs and
so there is a contradiction here. So why do you think, sir, the government would rely...
There was nothing done.
No, let me ask you, Mr. Tulsi, therefore, since you're endorsing the point we're making...
your story said that nothing was done by the UPA.
No, I'm not saying that, please.
I don't agree with that.
No, that's not true. I never said that. I don't think our story made any references to that. All we're saying is, sir, that certain pretexts that were taken by the UPA somehow are either contradictory or appear to be pretexts or technical arguments that don't really have any particular logic behind it. And that is the reason that we brought out these contradictions.
Just give
9 pretexts. Yes, sir. Please, go ahead.
Just give me half a minute.
Yes.
What I want to say is that these were not pretexts. These were genuine reasons. In fact,
okay.
If I recall correctly, these were the reasons given by Mr. Gopal Subramaniam.
True.
Even today, I feel that these are good reasons. And I do not know whether the setting up of an SIT where information has to be brought in from other countries is really a good idea.
Okay, let me open this out. Let me open this up.
15 or 17
That's a different
members.
point, sir. This is not about bringing information. This is about setting up of the SIT, whether it was something that had been mandated, was it needed to be set up? The UPA government, let me make it very clear. This is a narrow focus story on the objections the UPA had to the setting up of an SIT. The setting up of an SIT, which the NDA says was a leap forward in this fight to acquire black money from foreign capitals, as also nab the culprits. Now, Mr. Alag, I want to come straight to you. On the face of it, you can say that these are arguments. On the face of it, you can say that they have some sort of logical, legal rationale. But when it's not just one pretext, there are 9 pretexts, then it is a pattern.
You know, as far as I'm concerned, I'm not a lawyer or from the legal field. You've got enough people to discuss that. But all I can see is that this is a delaying tactic only, I think, to get people who do have black money to move it out, get out of the way, so that by the time we actually come and declare the stuff, you don't have the accounts, the money is gone, the governments can say, we don't have anyone by this name who holds an account. There can't be any other reason, because I don't think they delayed setting up a sit against Mr. Modi's 2003 riots. There was no such delay. Everything came into play. All the objections that have been raised for a sit thing would have applied to Mr. Modi as well. It was nobody raised these objections in the Supreme Court when the UPA was there. So I'm yet to understand, yes, technically what Mr. Tulsi is saying is right, but I think what was the objective of all this in delaying is the question that you forced the Supreme Court to come in and say, please sit up. Because you seem to be dragging your feet on getting something done. At the same time, I think Mr. Jaitley, I'm not here to defend him, he's also a lawyer. What has he done? He said, look, we are examining this. We do not want to embarrass anyone by putting out a name and finding out that he has a legal account, because people can have legal accounts as well.
That's fine, Mr. Alak. But the fact of the matter is, and let's look at the facts here. The fact of the matter is that we are focusing on the constitution of an SIT.
Right.
And the UPA seemed to have been dead against it. It extended at least 9 pretexts in court. The ones that seem to be completely out of place with a rationale is the one that we're highlighting. And I want to bring in Jaiveer Shergill of the Congress. Mr. Jaiveer Shergill, you've heard some of the experts. They all believe that fundamentally when you talk about or you take a plea that there was no request for an SIT made by the original petitioner and therefore we don't need an SIT, that doesn't stand up to scrutiny, because the SC and the HC have plenary powers to order an SIT, and I'm sure that the government would have known this. There were enough legal minds who know all of this. So why was this plea taken, Mr. Shergill? It's the intent we are questioning.
Okay, Rahul, just give me a minute, because
Please.
you've highlighted 9 pretexts.
Please.
Yes, definitely I'm going to answer you right away on the intent, and I'm going to keep it very focused on the constitution of the SIT. Number one, Rahul, what may seem to you be a technical argument, sometimes to a layman is necessary to preserve the principles of our constitution.
Okay.
Anyways, the reason for objection of constitution of SIT was very simple. Ms. Tulsi will agree with me on this. Whenever a Rahul SIT is formed, whether it was 2002 riots, it's on one basic principle. When a Supreme Court or any other authority or the petitioner feels that the investigation is not going in a manner it should be going, or it is not going according to the principles of the law. This is the basic principle on which a SIT is formed. When this observation of SIT was made, there was already something called HLC, High Level Committee, which had representatives from CBDT, ED, CBI, and which were working in a specific direction. So there were no allegations of them not working in a specific direction. There was no allegation of there being an inordinate delay, except the technical delays of procuring information from abroad due to our DTAAs. So that was our principle. Sir, where is the investigation? Already HLC, where is it going wrong that you need a SIT?
So you're saying...
It is very vital, Rahul. We must understand.
So you're saying that there was no real need to set up an SIT because the investigations were going in the right direction. There was
because
an
HLC was in place.
That was set up.
No, there was already a committee, HLC.
So you're basically hitting at the heart of the NDA's stand that you require an SIT, or even the Aam Aadmi Party stand that you require an SIT to probe this. Okay, let's open this out. Fine. Let's go point by point. I understand, Mr. Shergill. Let me open this out.
No, and Rahul, just 30 seconds. Yeah. Only on the principles, if you can prove that HLC is acting in an arbitrary, nullified, or
so
not
you're saying that if you can prove,
law, please appoint SIT
okay,
like
so you're
2002.
saying that there was no legal basis to conclude that the mechanism that had been set up by the UPA was not doing its job in delivering. That's what your basic argument is. Okay, let me... Fine, you can prove...
Please appoint SIT
okay,
like 2002.
So you're saying that there was no legal basis to conclude that the mechanism that had been set up by the UPA was not doing its job in delivering. That's what your basic argument is. Okay, let me...
How is the NDA saying that...
That was the argument we advanced. That was the argument we advanced. Supreme Court has given a verdict. Of course, we respect
just
that.
1 second. How is the NDA?
Sunil Alagh wants to come in. Let's show him.
How is the NDA in 7 months saying we will give you the results, and for 2.5 years, of course, you're moving in the right direction. It depends upon the speed. That's what Supreme Court has stepped in for, saying you can't take 2.5 years on doing a snail-paced scene when it can be done a little faster. That's the only point as a layperson. I'm not talking about the legal aspects. One other person comes in after sit, it's getting done in 7-8 months, and you take 2.5 years and do nothing. So I don't understand that.
Rahul.
Yes. Very quickly respond. I want to bring in Mr.
Rahul,
Justice Santosh Hegde also.
Very quickly.
Yes.
Yes. Rahul, this is, you as it says, NDA is going very fast. Rahul, just one question to Mr. Alagh. After May, one single name which the NDA has retrieved on their own account from these authorities, or one new agreement entered, or one treaty amended to do something to get this black money back. It is a horrible, a terrible anticlimax of all promises. If you can point me one effort, I concede my case.
No, but you are saying, and after 2.5 years, you'd have ended up with the same result as the NDA. So all that you are saying is whatever NDA is doing fast, we would have done slowly and arrived at the same
not
conclusion.
even for a second.
Then?
If you give me time,
Rahul,
the spade work.
This is Sunil Alagh.
I remember being on
Sunil Alagh is asking that question.
Would you have come to another conclusion if it was left with you?
Okay.
82 tax treaties.
Let me, one second, gentlemen,
82 tax treaties.
All
the spade work done. 200 crores received from French government in the tax recovery.
No. I don't see the money that came in on tax recoveries. You already declared it a long time ago.
Okay,
this
1 second,
to
gentlemen,
us
let's
that
not
what
get
have you
bogged
recovered
down.
from outside?
That's post facto. Let's look at the intention. I want to bring in Mr. KTS Tulsi and hopefully Professor Madhav Nalapat. You've seen some of these pretexts that were taken. Now, obviously, in the court of law, these are legal arguments. One side is won, the other side is lost. And today, in hindsight, people can say, oh, well, these were excuses, these were technicalities. But they all seem to point, as the NDA says, as the BJP says, in a particular direction, that there was no intent, there was no will. And all of these were, at some level or the other, sticking points that were raised by the previous government to delay, to obfuscate. Would you go along with that, Professor?
Rahul, I just want to say that the whole question will be one of intent. Let's not forget that information about black money held by high net worth Indians these would be the crown jewels of the investigative system. I mean, these are the deepest secrets of any government and any administrative authority, because it gives immense power, in a sense, not only to collect revenue, but in various other ways.
Yes.
Now, I mean, I'm not surprised that the UPA tried to protect these crown jewels from the court. And I was, of course, my eyebrows did get raised when the BJP handed over all these secret dossiers of information to the court, because now it is very clear that the government, the NDA, has set up a very clear precedent that this whole matter of black money, the SIT and therefore the Supreme Court is going to be in the driver's seat on that. So from that point of view, I don't think anyone can doubt the intent of the NDA, because it's very clearly now said we are, in a sense, giving the Supreme Court the lead authority role in uncovering black money.
Mr. Shergill, you want to quickly respond? I want to bring in KTS Tulsi on a couple of other points. Yes, Mr. Shergill.
Rahul, I just want to make a I want to make a fact check on the intent. Let's not forget, the court said, please hand us over. We will hand over to SIT. We have lost faith in you. Give it to us. Whatever has to be done, we will do now. So how can BJP even remotely take credit for this? Please read the Supreme Court order. It rather exhibits that the court lost faith in the government, in the way
the government. Yes,
today,
Rahul, began with the UPA. You're right.
Does the government have any role to
one at a time?
Sorry,
Mr. Alagh wants, yes.
Okay.
Professor wants to respond. Mr. Alagh wants to respond to you. J.V. Shergill, please, 1 second.
I just said,
Professor wants to respond.
They lost faith in the government. You're right. The first government has taken 2.5 years. They've come in for 3 months. So don't blame BJP. They were blaming the government for dragging its feet over 3 years, of which 2.5 years was with you. So I don't see what's the point you're making.
And also the fact of the matter is that this information was conveyed to the SIT.
One at a time, gentlemen, please.
SIT already had this information.
In July.
Mr. Jaitley was saying it's already with the SIT. Supreme Court insisted on getting it. Mr. Jaitley was only saying do not expose people and embarrass them if they actually have legitimate accounts.
That's a slightly, you're right, that's a slightly different argument, and I don't think we can mix it up.
Now the Supreme Court has kept it as a sealed envelope again, which
absolutely.
is already lined with SIT.
Justice Hegde joins us also. Justice Hegde, who was having a few problems with the audio. Justice Hegde, I find it a little strange that the government should have gone in and said that, you see, we can't set, the previous government, the UPA could have gone in and said that we can't entertain a request to set up an SIT because the petitioner had made no such demand in the original plea. They also went out to say that the SIT interferes with policy, impinges on doctrine of separation of powers. They went on to say that, look, it will cripple the functioning of statutory bodies when it knows that that may not be the case. The SIT jurisdiction is not defined, could shut down the government's machinery. It went on to say that SIT would probe unverified inputs and could lead to, you know, this entire thing being reduced to a witch hunt. It goes on to say that objections to inclusion of sensitive office of RNAW in SITs should be upheld. So, you know, there are a litany of reasons. Some people are calling them pretexts. Where do you stand on this, Justice Hegde?
I have no doubt every one of the pretexts was an excuse not to go further with the investigation. There were dozens of SITs were formed in various different cases. Nobody took an objection, and I don't find any legal support for such objections. The matter was being heard by the Supreme Court under the PIL jurisdiction, public interest litigation jurisdiction, where the role of the petitioner itself is very, very limited.
Yes.
The courts can decide not to hear him and proceed further on their own and all. In that jurisdiction, to put forward such defense or opposition for appointment of SIT on the ground that there is no definite law which prescribes the formation of SIT, these are all excuses, obvious excuses not to proceed with the investigation. I remember in 2008, I think it's Indian Express which published the names of 5 countries which the government of Switzerland gave to the media, saying that this is the quantity of money that is kept by the citizens of these 5 countries. From 2008, nothing was done. Why? Why was anything not done at all? Obvious reasons that government was protecting somebody. I am not interested in politics of this thing, but certainly a golden opportunity that was there. We have missed it, I think.
Okay. Mr. Shergill, would you like to respond? A very senior jurist has also taken
Rahul,
the position
yes,
that we are unspooling here, that these were all pretexts. Could you respond to him? And I want to bring in Mr. Tulsi right after that. Yes.
Okay. Yes, please. Right. Rahul, we are taking the objection to the formation of SIT as a delay tactic, and that is the basic argument which everybody on the panel is raising. Rahul, please see the record from 2008 till now. The amendments in the law, including Section 93 of the Income Tax Act, setting of income tax overseas unit in Singapore, and there are n number of those. Today, Rahul, the point is SIT the only way to deter, detect, and recover the money at that stage in 2011 from abroad? Our argument was no, there is another mechanism which is in place by the executive, so the court should not exceed its jurisdiction to overlap the investigation in absence of any challenge or finding that we are not proceeding in the right manner. It's as simple as that. And as far as our goes, Rahul, today, if I start counting the number of steps that are taken and that are fructifying, and the very fact
sir,
we are actually on the verge of identification and recovery is because of UPA.
All those names were never really submitted to the government. It happened under this, to the courts. It happened under this particular government. So many people are going to question you.
Rahul, because there are 82
Hegde,
information exchange agreements.
Are you satisfied?
Rahul, there
no,
are
one second.
82 information exchange
One second. Are you
agreements signed by us.
satisfied with this response, Justice Hegde? Does this address you?
Certainly not. The gentleman said there are many ways of investigating, and one of the ways is SIT. There may be many ways, out of which you have to choose at least one. Even that one was being opposed. Merely on the ground, there are statutory investigating agencies which had failed till then.
No, you had asked for an SIT, sir, in the Gujarat riots of 2002. Mr. Shergill, what happened? You didn't have a problem, and I want to bring
Rahul,
in Kartikeya.
Rahul, because
there
is an element of biasness of the state police.
No, you see, it's easy for you. The Supreme Court was looking at that particular case at that point. the Supreme Court was monitoring the case. And it was under the aegis of the Supreme Court that the SIT was set up. So the case had already moved out, if I'm not mistaken, Kartikeya. The case had already been moved out of the state of Gujarat. Kartikeya Sharma.
You see, yes, not only that, I think the larger picture, Rahul, here is that the black money is going to be part and central to the political discourse. And I would like to bring in Professor Nala Patani, hit the key right, because ultimately the whole elections of 2014 was geared on the black money issue, whereby non-state actors were mobilized by Bharatiya Janata Party. And it is on which for the first time, UPA had an advantage when the whole controversy happened after the names were leaked to the press. And I think this is the reason why this battle is going to continue, because this is one contention on which the NDA will have to come clean and have to prove that they have the intention and they have the intention and they have the political heft to ensure what they have promised come on the plate. Professor Nalapat.
You know, I just want to say, Rahul, that quite frankly, even now, I can't understand this argument of secrecy. Now, for example, the UPA, I am told, has exposed, I mean, the French government gave it some tax cheats. The UPA ensured that about 200 crores worth of tax revenue came from these. The point is that many of these transactions may not have been simple avoidance of taxation from legitimate business activity.
Yes.
Some of it may have been criminal. Now we are given everyone in that a free pass by assuming that everything was done in a legitimate manner except that tax was not paid. Now, had this been made public by the UPA, it could have transformed the political discourse. It could have led to many more such, information. My point is that if information is made public, the public comes out, more information comes. So, I just want to I want to add to what Kartikeya is saying. Millions and millions of people voted the BJP on the promise of getting black money back. Now, the UPA has concentrated on blocking the SIT.
Okay.
In my view, the BJP is now looking at outsourcing it to the SIT. If the SIT fails to get significant volumes of black money back, it means the BJP is going to pay a very heavy political price.
Yes, Mr. Tulsi, answer these questions, sir. On the pretext that were taken, the legal arguments that were extended by the UPA, did they at any level signify a lack of intent? I'm asking you a direct question today, Mr. KTS Tulsi.
I don't think it indicates the lack of intent. However, I do agree with the panelist who was just speaking that perhaps it would have been better to make these things public so that the country was reassured of what was being done. But on the other hand, I want to say that the honest intent of the government is proved from 6 steps that were taken apart from the Prevention of Money Laundering Act and the empowerment of various agencies. One was the Financial Action Task Force was set up precisely for this purpose. The Egmont Group was established for cooperation with other countries. Asia Pacific Group was constituted to be able to intercept the transactions. 22 tax information exchange agreements were executed with different countries. 22 during this period.
Sir, let's not go over that. You know, I understand. You see, there are vehicles and there are vehicles and there are vehicles.
The double tax avoidance agreements were entered into.
Mr. Tulsi, no one is arguing against that.
The Direct Taxes Code Bill.
We are looking at a narrow political point. Justice Hegde, I agree.
Everything possible.
You know, sir, one second, sir.
Everything possible was
there is no doubt
and it
that
is not
visible steps.
That there was any lack of intent.
So visible steps need to be taken also sometimes. You know, as justice is done, it also must seem to have been done. One of those visible steps was to constitute an SIT. And let's not escape that. Justice Hegde, your concluding thoughts. The SIT really was a test of intent.
I personally have always been opposed to SITs.
Okay, sir. That's your position. Justice Hegde.
Yeah.
Yeah. Who's opposed, who's not opposed is immaterial.
Yes.
And the Supreme Court felt under the facts and circumstances of this case, after so many years and so many steps allegedly have been taken, nothing was moving. That's why the Supreme Court thought it fit that there should be an SIT and directed the constitution of an SIT. That was opposed tooth and nail. And
there
various flimsy reasons were put up. You don't have the authority to put it. You can't monitor it.
No, carry on, sir.
1,077 prosecutions were launched.
Justice.
And 33,000 crore of rupees
Anyway, none of
transactions
the
were
names
being
came
monitored
out
by
at
the
all.
transfer
The people of
pricing
India
department.
wanted to know.
1,077 prosecutions were launched.
Justice.
And 33,000 crore of rupees
Anyway, none of
transactions
the
were
names
being
came
monitored
out
by
at
the
all. The
transfer
people
pricing
of India
department.
wanted to know who are these people who have.
Yes, Justice, carry on. Justice Hegde.
Well, if I'm interrupted like this, I think I'm not used to this. Look, you have asked me a question about my opinion in regard to the functioning of the SIT or
Yes.
the authority of the Supreme Court to appoint an authority, or the objection that the plaintiff had not requested the formation of an SIT. These are all very flimsy grounds. When a PIL is being entertained by the Supreme Court, the entire issue is in the hands of the Supreme Court. It can do anything which it thinks is necessary to reach a logical conclusion. All the 9 or 10 excuses given are absolutely flimsy.
Okay, let me bring in Mr. Mahesh Jethmalani, leading senior lawyer. Mr. Jethmalani, we've just put out a story which reveals for the first time the exact specific details of the UPA's defense in the Supreme Court of its own position that an SIT was not needed in investigating the black money trail. Now, one of the pretexts it relied on was that there was no need to set up an SIT because no request was made in the first place by the petitioner, knowing fully well that the Supreme Court and the High Court have plenary powers to order an SIT. The other pretext they took was the SIT interferes with policy, impinges on doctrine of separation of powers. Mr. Jethmalani, if you can hear me. The contradiction there, of course, was that the SIT can't interfere in policy matters. Yes, are you there with me, sir? Can you hear me? Mr. Jethmalani? Can Mr. Jethmalani hear me? I don't think we have him. We don't have him. We are going very quickly once again. Okay, Mr. Jethmalani, can you hear me, sir?
Hello?
Can you hear me, Mr. Jethmalani? Okay, we're having a few communication issues.
Hello?
I think we're having a few communication issues with Mr. Jethmalani. Very quickly, I want to wrap this up by giving Mr. Shergill one last opportunity to defend the government's position here, that this was not frivolous interventions aimed at derailing or slowing down the move towards constituting an SIT. You've heard Justice Hegde, you've heard others on our panel. Quick 2 points from your side, Mr. Shergill, uninterrupted.
Quick 2 points, Rahul. Number one, the objection to formation of SIT cannot cast a shadow or doubt on our intent, because as a lot of work we have done, that is why we have reached this stage. Second, SIT need was not felt at that particular time because the HLC was in place, which was doing its investigation in a proper course, and there were no allegations against the HLC that they are not acting according to the law, and that is why these were legal objections were there, but Supreme Court overruled that. We respect their verdict, and I truly believe now BJP should not change its color and tone towards this entire issue, and not go on a fishing expedition, because commitment alone cannot bring it back. Actual documentation will bring the black money back, and they should get going with it.
Well,
so
documents on both sides of the fence.
You want the BJP to do exactly what you never did. Ultimately, that's your conclusion. We couldn't do it. You please do it.
Okay.
Is that the conclusion?
Sir, Benami Prohibition Transaction Bill. Benami Prohibition Transaction Bill was lapsed because of BJP, the biggest preventer of corruption of property. Because of your
gentlemen, you see, we're constantly on both sides.
The trouble with Congress is when they cannot answer a question, they bring out another issue. Altogether, we are discussing this one case.
Keep it focused.
That's all. If you want to discuss focus for our viewers, at least on this one, you have to conclude
the verdict
that
is out there. Gentlemen, 1 second, please. Let's not get into this.
That's all.
The verdict is out there. The viewers have heard both sides. It's up to them now to decide. We're going to take a quick